Good afternoon, everyone. Thank you all for attending today's webinar on AB 626, what it means for public works projects and what public agencies need to do to comply, presented by Ben Reyes and Eric Kasher. A couple of housekeeping items. All of your telephone lines are muted. If you would like to ask a question, there is a Q&A box at the top of your screen. Please type your question in this box. Ben and Eric will be holding all questions until the end of the webinar. We have a lot of folks registered for today, so if your question isn't answered, Ben or Eric will follow up with you after the webinar via email. We are offering CLE credit for this webinar. If you check the box on your registration form to receive credit, a CLE form will be emailed to you. We will also distribute all slides to attendees early next week. Now to introduce our speakers. Ben Reyes counsels the firm's clients in the areas of municipal and public agency law, energy, construction, procurement, and elections. He is the city attorney for Pinole and Union City and serves as general counsel for the Siege Sanitary District and assistant general counsel for the West Contra Costa Transportation Advisory Committee. Ben chairs the firm's public contracts practice group. Eric Kasher has been assisting public and private clients with legal and regulatory matters throughout California for nearly 10 years. His comprehensive experience ranges from public law and public contracting to construction litigation, workplace investigations, and public-private partnerships. Eric has a particular focus on the broad range of challenges that government agencies, cities, counties, and special districts face as they implement their mandates and missions. Eric is general counsel for the East Bay Dischargers Authority and a commissioner with the California Fair Political Practices Commission. That is all for administrative matters. I will now hand it over to our presenters.
Thank you, Stephanie. Good afternoon, everyone. This is Ben Reyes. Thank you for the introduction. I'm joined today by my colleague, Eric Kasher, who is a member of our public contract group. And before we start, just a word about our public contract practice. Our group is a group of attorneys that provides legal advice to public agency clients primarily on construction specifications related to public works projects. Another housekeeping rule is that I will be taking the first half of the presentation and will be followed by my esteemed colleague, Eric Kasher. And since there were over 200 of you attending this webinar today, we would ask that you please, again, please send us questions. We may not be able to get to all of your questions because of the number of participants, but we will do our very, very best with your email information to answer every question that you send to us today. So we wanted to give you an overview of this new legislation, AB 626, and the outline of our entire presentation is this. We have nuts and bolts, compliance with AB 626, which Eric and I will split, and then Eric will talk about the next steps. Let me first talk about the background of AB 626. This new legislation adds Section 9204 to the Public Contract Code, and it adds it to Chapter 9 of the Public Contract Code that relates primarily to claims and disputes. It applies to any claim by a contractor in connection with a public works project, and it applies to public works contracts, as I will explain in a couple of definitional slides. It applies to traditionally construction projects. AB 626 does not apply to consulting services contracts, to personal services contracts, or to contracts for the purchase or sale of goods. And I will elaborate on that. This new provision became effective on January 1st, 2017, and it's a pilot piece of legislation, and by statute it will sunset on January 1st, 2020. AB 626 was authored by San Francisco Assembly Member David Chu and Cupertino Assembly Member Evan Lowe. 626 establishes essentially a claims resolution process for public works projects for state and local public entities. It specifies, among other things, primarily that contractors can submit claims to public entities. Then public entities have 45 days to provide written responses to the claims that details disputed and undisputed amounts. It applies to all public projects and apparently to all claims regardless of the dollar thresholds. The intent of the author essentially is to ensure that undisputed portions of claims are paid in a timely manner, and the legislation provides mechanisms to resolve disputed items. In part, as Eric and I will explain, it overlaps with other dispute resolution legislation already in the Public Contract Code. When we were reviewing the legislative history of this bill, we note that the author and the Senate Judiciary Committee were concerned about delays in payments for extra work and the failure of public entities to issue change orders or to deny a claim. And the legislature had acknowledged that these types of delays places contractors at financial risk to their employees. On the other hand, however, the League of California Cities and a number of public agencies have opposed this bill because it creates administrative burdens on public agencies to comply with new provisions that appear to be somewhat duplicative in other portions of the code. Now let's discuss what a claim is under AB 626. A claim is defined as a separate demand by a contractor sent by registered or certified mail with return receipt for one or more of the following. A claim is defined as a time extension, including a claim for relief from damages or penalties for delays. A claim is also defined as a payment by the public entity of money or damages arising from work done by or on behalf of the contractor pursuant to a contract for public works projects, and payment for which is not otherwise expressly provided or to which a claimant is not otherwise entitled. And a claim is also a payment of an amount that is disputed by a public entity. 2 points that I would like to make about this particular definition on the slide. Note that the new statute requires that claims must be sent via registered or certified mail. So the past practices that some contractors have observed, which is to deliver by hand or sometimes by email electronic claims, are explicitly not recognized by statute. While a contractor can submit a claim by hand delivery or by email, most notably a claim is only recognized when it's sent by certified mail or registered mail with a return receipt. The second bullet point on this slide I also wanted to highlight. The second bullet point says that this is a claim is recognized as payment by a public entity of money or damages arising from work done by or on behalf of a contractor. This, for the very first time, this language appears to allow a contractor, and Eric will go through this, to pass through a subcontractor's claims. This is legally important because, as many of you know, public entities do not have what's called contractual privity with subcontractors, and there is no real direct means by which a subcontractor can submit a claim directly to a public entity, and a public entity does not have the legal ability to deal with claims outside of a contract. Also, it's legally important because in some cases, this pass-through provision defeats indemnification provisions that are often contained in contracts. The definition of a contractor is basically any type of contractor within the meaning of the Business and Professions Code. If you look up Section 7000 of the BMP, that's essentially the section that relates to contractors who are licensed by the Contractor State Licensing Board. So essentially, a contractor is any licensed contractor. Now, on its face, Section 9204, or AB 626, appears to be broad and encompassing. Again, it's codified in Chapter 9 of the Public Contract Code, so it applies basically to all state agencies and state departments, to the University of California and the California State University, and it applies to all cities and counties, including charter cities and counties, special districts, public authorities, political subdivisions, public corporations, and nonprofit transportation corporations wholly owned by a public agency and formed to carry out the purpose of a public agency. While it does state that in the definition section of AB 626, what's really interesting is that it carves out exceptions. So under the statute, a public entity does not include the Department of Water Resources or any of their projects. Interestingly enough, the legislation excludes Caltrans, the Department of Transportation. It also excludes the Department of Parks and Recreation and the Departments of Correction and Rehabilitation. It also excludes the California National Guard or the military department of the state, and excludes the Department of General Services and the High-Speed Rail Authority. So essentially, it applies to all public agencies of the state, ironically, except for the state departments which bid out the most public works projects. So a contractor, excuse me, I hit the wrong button there. So a public works project means the erection, construction, alteration, repair, or improvement of any public structure, building, road, or other public improvement of any kind. This slide is really important because the new legislation appears to maintain a different definition of a public works project than some of the definitions that most of you are used to. For example, a public project under the Public Contract Code for the general law cities are very precise, and you may encounter a situation where a public project may be handled a certain way under the definition for a construction project, but for the purposes of submitting a claim under this more expansive definition under AB 626, a contractor may submit a claim for a public works project which was not originally intended to be a public project under your competitive bidding codes. So there seems to be some confusion in the statute with the addition of the new definition. One thing that appears to be clear, however, is that this new statute does not appear to apply to maintenance projects. Okay, the last slide that I'm going to talk about is what is a subcontractor under the meaning of AB 626. So a subcontractor means basically any type of contractor within the meaning of Chapter 9 of the Business and Professions Code, which again is a licensed subcontractor. Pursuant to AB 626, a subcontractor must present reasonable documentation to support a claim through a contractor, and within 45 days of receipt of a claim, a contractor shall notify a subcontractor whether or not its pass-through claim was presented to the public agencies or the reasons why a claim was not presented. So I'm going to turn it over now to Eric to go through the remaining of the slides.
Great. Thank you, Ben, and thank you all for joining us today, this afternoon. The next couple of slides, I'm going to be focusing on the steps and the procedural aspects of the statutory requirements under AB 626. What we've done is we've taken the language of 626 and the statutory requirements under Section 9204 of the Public Contract Code and broken those down into 14 steps that we think you will find useful in helping to navigate this situation where there's a claim that's filed on a public works contract involving your agency. So the first step that we have here that I'll be describing is upon receipt of a claim, a public entity must conduct a reasonable review. Now, Ben indicated earlier that it's not enough that there is a change order request that's submitted and there's a rejection of that request or there's a dispute regarding the amount that the public agency will be willing to pay on that request. A claim is only submitted when there has been a separate demand by the contractor sent by registered or certified mail with return receipt requested. So unless the contractor submits the claim in that fashion, they have yet to invoke their rights under AB 626. So make sure that before you start reviewing that claim, that they have complied with all of the procedural requirements to essentially invoke this section. There's an important word in here, and that is that the public entity must conduct a reasonable review of the claim. It's not enough to receive the claim and just reject it out of hand. I would recommend that you take the time to have your project manager or your design professional or somebody who might be managing the project for you to take a long look at the claim, because you'll see in the second step that within a period of not to exceed 45 days, the public entity must provide a written statement identifying what portion of the claim is in dispute and what portion of the claim is undisputed. So that reasonable review must be sufficient for the public agency to determine whether or not there is anything that remains in dispute, whether the entire claim is in dispute, and that written statement within 45 days must reflect what's in dispute and what's not in dispute. I also want to note that there are a lot of time restrictions and requirements in this particular statute. The statutory language provides that the parties themselves may agree in writing to extend any time period. So if you receive a claim via certified mail, certified or registered mail, and you don't understand the claim, you need additional information, you can request that of the contractor who's submitting the claim. And I would encourage, and it's probably a good idea, to seek some form of an extension on that 45-day period to provide a written statement. The parties can agree to that, and that will slow the process down a little bit and give everybody some time to evaluate the claim properly. The third step indicates that the claimant shall furnish reasonable documentation to support the claim. So this goes to my prior point. If the claim is received and it simply says the project has been delayed 15 days, our out-of-pocket costs are X amount, we are entitled to payment for those delays, that would likely be rejected as not providing sufficient information. The contractor would need to describe why it is that the delay occurred, why it is that the public agency is responsible for that delay. How did they quantify the amounts that they're seeking as damages, or those actual damages, and that type of information. So the public agency can and should request that there be full documentation to support the claim. All right. The fourth step, if the public agency needs approval from a governing body and the governing body doesn't meet for 45 days or within the mutually agreed extension, the public entity shall have up to 3 days following the next publicly noticed meeting to provide a written statement. So if your council or your board is required to approve payment of a undisputed claim, for example, or if it's required of your council and or board are required to approve any any additional payment under a public works contract, what this says is that you won't be penalized for not meeting that 45-day deadline as long as that governing board makes that determination and approval within 3 days of their next scheduled meeting, publicly noticed meeting. Okay? Under Step 5, any payment due on an undisputed portion of the claim shall be processed and made within 60 days after the written statement. So you receive the written statement, you conduct a reasonable review of the claim, you make a determination as to what is in dispute and what is not in dispute, and what the statute essentially provides is that if there are amounts that are not in dispute and you as a public agency agree that there needs to be a payment made, then you need to do so within 60 days after the transmittal of the written statement. And that's important because the statute also provides that there is a 7% annum penalty associated with not making a timely payment on an undisputed amount. Okay? And I'll touch on that a little bit further on in the presentation. Moving on to the sixth step. A failure to issue a timely written statement shall result in the claim being deemed rejected in its entirety. So you have 45 days from the time you receive the claim to submit a written response. If there is no written response, then it's assumed that the claim is being rejected in its entirety, and the contractor would then move on to the next phase of exhausting its administrative remedies. And that would include, the next step being if the claimant disputes the written response, or if the public entity fails to respond to the claim within the time prescribed, the claimant may demand in writing an informal conference. So, if the public agency receives the claim, they choose not to submit a written response, then at that point, the contractor is within its rights under this section to demand an informal conference. They must do so in writing, but they would be entitled to an informal conference at that point. And the public agency would be required to attend that conference and participate. That would also apply if if the written response by the public agency disputes the claim. So then an informal conference will proceed. Under Step 8, upon receipt of a demand in writing sent by registered or certified mail, return receipt requested, the public entity shall schedule a meet and confer conference within 30 days. So a claim is filed, you either file a written response or you don't respond at all. At that point, the contractor can demand an informal conference, and if they do so in writing via registered or certified mail, then the public agency is required to schedule a meeting in person within 30 days of that time frame. Under Step 9, within 10 business days following the conclusion of the meet and confer conference, if the claim or any portion of the claim remains in dispute, the public entity shall provide a written statement identifying the portion of the claim that remains in dispute and the portion that remains undisputed. So you have an informal meet and confer conference. 10 days following the conclusion of that meet and confer conference, you have to turn around immediately and provide a written statement regarding what is in dispute and what is not in dispute. Now, the facts may not have changed, and the agency may not be persuaded by any of the information provided, so that may be fairly straightforward. But if there's progress made at the meet and confer conference and the position of the agency has changed, 10 days is a pretty quick turnaround to get out a statement on those disputed and undisputed portions of the claim. So these are pretty tight time frames, so make sure that you have staff on board who are very involved and engaged in this process, and that you're being mindful of these time frames because they're all required under the statute. Under Step 10, any payment on the undisputed portion shall be processed and made within 60 days after the public entity issues a written statement. So 60 days to make payment on that claim if there are no longer any disputes as to a portion of it. Any undisputed portion must be paid within 60 days. Step 11. Any disputed portion of the claim identified by the contractor in writing shall be submitted to non-binding mediation with the public entity and the claimant sharing the cost equally. So this is a pretty significant and drastic change from the existing law. This essentially entitles a contractor to, under any kind of a claim, it could be a disputed change order during construction, they can go through this process, and as long as they meet the procedural requirements, they can demand non-binding mediation with the public entity. So you could imagine the situation where you might be halfway through construction on a project, the contractor's out there performing work, everybody's doing what they need to be doing, there's a dispute that arises regarding a change order, for example. You make your way through this process and you find yourselves 45 to 60 days later in a mediation with the contractor on one of these disputed claims. And as Ben mentioned, there is no monetary threshold for the type of claims for which this might apply. So it could be a claim that's somewhat nominal in the amount, or it can be a high dollar amount. So you could also imagine the types of disruptions that this may create on a project site when you have parties that are now being forced into mediation. You're pulling staff off of the project site to deal with this issue, to help provide facts around in context for the responses to the claim and the defense to the claim. So there can be inefficiencies created in the execution of the project as a result of this. So that's something to keep in mind as you are executing on these contracts. The 12th step. Within 10 business days after the disputed portion of the claim has been identified in writing, the public entity and claimant must mutually agree to a mediator. So my suggestion here is that if there's a claim that's submitted under AB 626, there's going to be a chance that it makes its way to mediation. I think a best practice for public agencies would be to have a panel or have a couple of mediators that you are familiar with and that you can draw from to assist in these types of situations. Mediators are often very, they tend to get booked pretty far out, and sometimes they're hard to come by, so I would recommend having a list of maybe 3 to 5 mediators who you may be able to contact to assist with these types of matters, and that you could then submit the names of these mediators if this type of a situation arises. Under step 13, if the parties cannot agree upon a mediator, then each party will select their own mediator, and those mediators will select a qualified neutral third party. So if the parties all agree to which mediator will be used, then you could proceed with that particular mediator. If the parties are unable to agree on the mediator who will handle this particular dispute, then each party will select a mediator, and those two mediators themselves will come up with a third-party neutral mediator to mediate that particular session between the parties. Now, keep in mind, this is non-binding mediation, so this is essentially the statute forcing the parties to get together to try to talk through some of these issues with a third-party neutral present, with the hope that the dispute will be resolved. But it's non-binding, so if the parties do not agree to a settlement or to full resolution of the claims, then you're going to proceed to step 14. Under step 14, if the mediation is unsuccessful, the parts of the claim that remain in dispute shall be subject to the applicable procedures outside of AB 626, and that includes litigation and arbitration. So at that point, the contractor has then exhausted their administrative remedies under 626. They've submitted their claim. They've gotten a written statement from the public agency in response. They've requested an informal meet and confer conference. That didn't resolve the case. They then demanded a mediation with a third-party neutral. That did not resolve the case. And it's not until that point that the aggrieved party may then submit a civil action to the superior court, or if there's an arbitration provision, then arbitration would apply. So those are the kind of the procedural steps that relate to this particular bill. There's a couple of other things that we wanted to point out to keep in mind. When you are drafting your contract, so keep in mind AB 626 applies to any public works contract that is awarded post-January of 2017. So any contract that you are currently letting out that fits the definition of a public contract or of a public works or a public contract under this section AB 626 will apply to all of those. And it also requires that the reference to 626 be included in the plans and specifications for all of your public works projects. Now, it's not enough that there be a reference to Public Contract Code 9204 applying to the contract. The language of the statute states that you must either include the language of AB 626 in your specifications, or you must include a summary of AB 626 in your specifications. The idea here being anybody who's bidding on the contract or being awarded the contract should be aware of these requirements under 626, and contractors should be entitled and put on notice of their rights under 626 and the claims process that's set forth therein. So if you do have specifications that do not include language that reflects the requirements under AB 626, make sure and consult with your city attorney and or general counsel to make sure that these sections in language are added to your specifications. We also wanted to note and made sure you keep in mind that you cannot waive the rights that are granted in AB 626, but the parties can mutually agree to waive in writing mediation and proceed directly to commence or a civil action or non-binding arbitration. So what that means is if the contractor wants to submit a claim through the claims process under AB 626, but they would rather not do that, and both parties agree that, you know what, we don't think that an informal meeting is going to be beneficial. We don't believe that a non-binding mediation is going to resolve this. Both parties can agree at that point in writing to allow for the case to move forward in a civil action in the Superior Court or in the form of arbitration. In addition, a public entity can prescribe reasonable change order, claim and dispute resolution procedures and requirements in addition to AB 626, so long as there is no conflict with the time frames contained in AB 626. This is important because many of you, especially those who are public works and who are very familiar with your project specifications, there's oftentimes an entire section and there's language in there that relates to dealing with disputed change orders and dealing with dispute resolution that occurs on your projects. What this says is that you can still have those provisions in your contract, but you want to make sure that you take a very close look at them to make sure that they don't in any way conflict with the requirements of AB 626. So make sure and keep that in mind. And that's another one that would be useful for you to contact your city attorney or your general counsel to make sure that your existing dispute resolution provisions are not inconsistent with the requirements under AB 626. Also wanted to point out that if the public agency does not comply with the timeline, so if you do not submit a written statement in response to the claim within 45 days, the claim is deemed rejected. And as mentioned before, if there is an undisputed amount that is not paid following a claim, then that shall bear interest at 7% per annum. Now keep in mind, and many of you are probably familiar, there are already prompt payment statutes under the Public Contract Code. Under the prompt payment statutes, the penalty for not making a timely payment under those requirements are 2% per month or 24% annually. It's unclear at this point whether or not both of those penalties could apply to a situation where there is both a failure to comply with the prompt payment penalty requirements under the statutory law, and then also this a failure to make a payment on an undisputed claim that is submitted through AB 626. That's an open question, and we're not sure exactly where that will where the courts might come down on that. Okay. So a couple of next steps here. As indicated, AB 626 and all of these requirements under Public Contract Code 9204, they are required for all public works contracts entered into after January 1st of this year. So again, make sure that you contact your city attorneys and or general counsels to make sure that your project specifications are updated, that they include more than just a passing reference to Public Contract Code 9204, but that they actually include the language or the pertinent language of AB 626 and or provide a summary of what's required under AB 626. Please make sure and consider developing internal procedures for your claims process. Identify who will respond to the claimant, who will decide if documentation submitted is sufficient, and then who will review the claim to identify disputed versus undisputed issues. This is really important because the time frames are really tight under this requirement, these requirements. And if it's a smaller project, as many of you may be familiar, you may not have a construction manager who's out there managing these types of disputes for you in the field. It may be someone within your agency who is serving as the project manager. And if there's a claim for delay, for example, you may be required to do some scheduling analysis. And that might require or involve the need to retain a scheduling consultant or someone who, or a design professional, someone who's familiar with analyzing delays on a construction project. That could take time to retain that individual, to get them under contract, to get them a copy of the claim, and to have them conduct that analysis. So we recommend, I think it might be a good idea to make sure that you have a process in place for dealing with these types of claims. Of course, you don't really know where the claims are going to come from and what they may relate to. But I think it's a good idea to make sure that you have a process in place so you're not losing time and you're not running up against any of these timing deadlines. Another thing that I might recommend is, there's oftentimes a design professional or an architect or engineer who's involved in the initial phases of the development of your contract documents and your design and your plans. It might be good to include some additional language in their scope of work so that they are kind of available for you in the event of a claim coming up during construction. So you've already got a design professional or a professional service provider who's under contract who's essentially required by their contract to step in and provide these services for you. That's just something else that you might consider doing with your contracting. In addition, determine what, if any, other claims processes the public agency will have to comply with. AB 626 is one requirement. Ben made reference to Public Contract Code 2104, which is another dispute resolution section of the Public Contract Code that also still applies because they are to be read together, but they don't kind of rule either one of the two out. So figure out which of those might apply. As Ben indicated, if you have language in your standard specifications that tracks the language of 2104, make sure that your inclusion of AB 626 doesn't in any way conflict with that, and that there's harmony between those two. That's something that's going to be important, and that's something that we're all going to be kind of struggling with and trying to figure out how best to do. And then finally, as I mentioned before, prepare a list of mediators or arbitrators who can be ready in short order, who you're familiar with, who you can rely on and call upon in the event that there is a dispute or a claim that's submitted and a dispute related to that. Any questions?
Yeah, before we move on to questions, there are just a couple of observations that I have. Eric and I, in practicing public contract and public works project law and advising our clients, we have traditionally maintained a philosophy that if there is a dispute on a project, you get the contractors and the public agency to focus on completing the project and then dealing with disputes after the project is completed through a claims process. And most of the contracts reflect sort of that philosophy. Well, AB 626 and the new Public Contract Code 9204 now no longer permits public agencies to dispense with that type of handling of public contract disputes, and it basically forces all parties to try to resolve the disputes early on, and oftentimes, as Eric has mentioned, within the course and scope of the project. So that creates all kinds of complications, which I think are unintended consequences of this legislation. A couple of things that I would also like to offer for your consideration here is that nothing in the statute requires requires a public agency to pay for work that they did not approve or do not agree with. So there's nothing that compels a public entity to do that. Nothing in this statute requires a public agency to forego contractual arbitration processes. And nothing in this statute overrides the government claims requirements that are already required by law. So this is an interesting piece of legislation that creates unnecessary complications because, as Eric and I had mentioned, it does not repeal other alternative dispute mechanisms by statute that are already existing, and they seem to overlap with and internally conflict with some of those provisions. So careful reading of your specifications and careful fine-tuning of your specifications are needed in order to comply with this law. With that, we're going to start taking some questions, and we're going to try to get through all these questions in the time that we have. So why don't you go ahead, Eric, and I guess you.
Okay. So one question that we received is, and I'll just read it out. Since this is a state law, if the city fails to insert the language in a purchase order or bid spec, would it apply anyway? So it does apply to any and all public works contracts that fit the definition as set forth in Public Contract Code 9204. Ben made the point earlier that the definition in 9204 is a little bit different than how public work is defined elsewhere in the Public Contract Code, in particular as it relates to competitive bidding. So make sure that you are very familiar with the definition that applies under 9204, and yes, it would apply. But I'll add, the statute also requires that public agencies who let out public works contracts include the language in their bid specification. So yes, it would apply, but there's also a requirement under the statute that the language be included in the specifications. And we have yet to see this play out, but I could foresee a situation where a contractor, for example, isn't aware of the requirements under 626. The language doesn't appear in the bid specification, and I would think that the public agency might unfortunately be in a position where they maybe have waived some of their rights vis-a-vis AB 626 if they haven't done that. So if a contractor claims that there wasn't, some sort of compliance related to that, and it's not in the contract, which it's required to be, that could raise an issue for a public agency. So again, best practice, make sure that the language is included so that you don't have to deal with that type of a situation.
So another question we have here is, how is the term public works project defined for charter cities, by SB 7 or by city charter or by laws? Essentially, and this is what I was trying to explain, and Eric had tried to explain in his last explanation here, is that the public works definition for your charter city may vary by what the charter contains or by SB 7. This piece of legislation specifically relates to claims, and claims are defined rather broadly. And I will provide you with an explanation offline to the person who asked this question too. Another question is, does AB 626 apply to local government agencies? And and also an attendant question is, let me see, does AB 626 apply to joint power agencies? You'd have to take a look. I can argue it on both sides. The definition of a public entity is a state agency, a department, a city, a charter city. It also includes a public authority, a political subdivision, a public corporation, or a nonprofit transportation corporation. And on one hand, we can argue that a joint powers agency is a type of a public authority, but the statute doesn't necessarily go into an explanation of what that is. On the other hand, an argument can be made that the legislature knows how to craft the definition, and if it intentionally excluded in its definition a joint powers agency, then a joint powers agency is probably not included in the definition of AB 626 for its claims purposes. The only other provision that the only other explanation that I can offer in answer to this question is sometimes joint power agencies have in their joint power agreements the rules by which they would necessarily handle or conduct claims and or resolutions or disputes of this type, and you may have to look at what the JPA agreement says about which laws apply to dealing with public contract or public works projects.
Okay, we have another question here. Does AB 626 apply to service contracts such as landscaping maintenance? The definition of public works projects under AB 626 includes the erection, construction, alteration, or repair or improvement of any public structure, building, road, or other public improvement of any kind. The state legislature has included maintenance in other definitions. They chose not to include that here. So we don't believe that AB 626 applies to landscape maintenance or maintenance projects.
So there was the question as to whether or not AB 626 applies to counties. Yes, it does. Another question is, if a local agency's funding was provided in whole or in part from Caltrans, the California Department of Transportation, would the project be excluded from AB 626? That's an interesting question. This statute does not relate to, or does not speak about whether funding sources would dictate the process for dispute resolution. I think you would have to look at whether or not the local agency is included in the definition of a public entity. So, for example, if a city receives funding from Caltrans to resurface roads which are traditionally public highways, and the city is performing that type of work, the city is included under the definition of a public entity, and therefore it would follow that AB 626 rules would apply to a dispute arising between a city and and that city's contractor.
You've got a question here. This is in reference to number 11 in the 14-step guide that we provided in one of our slides. That slide reads, any disputed portion of the claim identified by the contractor in writing shall be submitted to non-binding mediation with the public entity and the claimant sharing the costs equally. And so the question is, non-binding mediation is only needed if parties initially don't agree on the claim after steps 1 through 10. And that's correct. If this is really a right of the contractor to request non-binding mediation, so if there remain any items that are in dispute, then the contractor can request and require mediation, non-binding mediation with the public agency as it relates to any remaining items in dispute.
Another question here is, does this process supersede the Government Claims Act process? And the answer is no. I think in one of my concluding statements, I indicated that AB 626 does not override the government claims requirements, and contractors are still required to present a claim if they are to pursue litigation against a public entity.
There's a question here, does AB 626 apply to federally funded contracts? That's a good question. I think it's somewhat uncertain. There's a question. There's a lot of overlapping requirements for federal contracts, prevailing wage versus Davis-Bacon, and there's some case law that's out there that gives some guidance on when the federal requirements would apply versus the local. This is a new statute and a new requirement, so it's not clear how this would apply. But as a rule of thumb, if there is local funding that's going towards this particular project, and it fits the definition of a public work under Section 9204, I think best practice would be to include that language in your specifications for that particular project, and just plan on allowing for this particular statute to apply.
Okay, there was a question on what are the legal or practical consequences of omitting a summary of AB 626 in your bid packet. The statute doesn't say if there are any, in fact, it omits it. It doesn't set forth any legal or practical consequences for omitting the summary of it. It just compels us to go ahead and include the summary in AB 626. I could imagine perhaps an attorney indicating that the specifications themselves do not comply with the law, and the statute would override anyway, notwithstanding what the contract provisions indicate in a particular jurisdiction's specifications. So I'm not necessarily sure that I've answered this question correctly, but I think what we're required to do is we're required to include now the summary and or the provisions of AB 626 in specifications in order for them to comply with the law.
Here I got another question here. For contracts entered into after January 1st, 2017 that did not include the AB 626 provisions in the original bid specifications, do you recommend amending those contracts to add the new claims provisions? That's certainly something that can be done. The statute requires that any contract let out after that date include that language. So I would recommend, and I think it would probably be a good idea to amend the contract to include it, because the section of 9204 would apply, and so if the contractor does have a claim that occurs, at some point during construction, they're going to need to be on notice of the requirements under AB 626. So amending the contract to provide that language, I think would be a good idea.
We're scrolling through these questions here. Let me see.
And thank you for the questions. These are good ones.
And we may not be able to get to everybody. We'll try our best to do so in the 8 minutes that we have left. Let me see.
There's one down here at the end, and I'll take it because it's an easy one. Is it true that AB 626 is scheduled to sunset in 2020? And yes, that is true. This language in this section was put into place effective January 1st of 2017. It is scheduled to come off the books in January of 2020.
Yeah, okay. So there was a question here. Given that the statute exempts the majority of state contracting agencies, isn't the statute vulnerable to challenge by charter cities and counties as conflicting with constitutional home rule authority over contracting? That's a very good question. There doesn't seem to be a reconciliation of how this statute conflicts or overrides constitutional home rule authority provisions by declaration in the statute itself. The statute has the typical language that you see, that these issues are sort of a statewide concern, and therefore it seems to try to challenge the provision of the constitutional home rule authority. But I agree with this question that this statute may be vulnerable to a challenge by charter cities. So there's another question here. If your project is subject to Caltrans claims procedure and or Public Contract Code 20104, which procedure do you follow? That's a very good question because, again, this statute was enacted and it did not statutorily repeal the other provisions that are already existing in the code, particularly under Public Contract Code Section 20104. So you have to read this procedure in the context of the existing provisions under Public Contract Code 20104, which applies to all claims under $375,000 and sets forth very specific procedures for claims between $50,000 and $375,000. So you have to read them in the context of each other, which is very difficult, admittedly. You have another question here, Eric? Let's see. This is a question for you, Stephanie. Can Q&As be included in the email out next week? Also, can we get a copy of the recording to share with our staff?
Yes, we can. I'm happy to include the Q&As in the email that will go out. That will include MCLE credit forms as well as the PowerPoint slides. If you would like a copy of the recording to share with your staff, please email me directly at shill@myersnave.com. That recording will be available early next week.
Okay, so there's a question here. You mentioned that AB 626 doesn't override dispute resolution procedures in the contract. For example, how to resolve disputed change orders, as long as those procedures don't conflict with AB 626 requirements. Question, do you think it would be defensible to state that a contractor must go through the informal contract dispute proceedings before submitting an AB 626 claim? Do you have any thoughts on that, Eric? I'm thinking that what Eric had mentioned earlier is that you can't enforce provisions in your contract that are inconsistent with the timing requirements of AB 626. So to the extent that they do not conflict with the 45-day and the other time limits that are imposed by 626, I believe you can legally require adherence to contractual dispute mechanisms that are already in your specifications without running afoul of AB 626.
I think that's right, and there's a couple of other questions regarding the government code claims process and how this relates. And the way that I view this particular statute, this is really these are rights that are afforded to the contractor. So if the contractor invokes its rights under AB 626, it wants to require that there be a written statement responding to the claim, and wants to have an opportunity to have an informal meet and confer, and wants to have the opportunity to mediate a claim. Section 9204 allows them to do that. And so if you have a dispute resolution provision that maybe it tracks the government code section, if there's a conflict there and the contractor is saying, no, I want to have this written response and I do want to have this opportunity, I think that it may not be defensible for a public agency to say, no, we're not going to give you that meet and confer, no, you're not entitled to mediation, when Section 9204 clearly provides them with that right.
I agree with that. There's another question here. I'm sorry, let me see. It just went down. It's another question about the conflict between this new legislation, AB 626 and 20104. If AB 20104 has shorter deadlines, should we just mandate using the shorter deadlines? And I don't know how to answer that question without advising people to comply with both. And if there's a conflict, which again, this statute does not statutorily repeal provisions of 20104, you're going to have to, no matter how difficult this is, try to read them in tandem with each other, which I don't think the legislation provides any guidance on. Another question, do you recommend discussing AB 626 during the pre-construction meeting with the prime contractors? Absolutely. I think this is so new that quite frankly, I don't believe that most of the contracting community is really aware of the provisions of 626. So I think it would be a good practice to discuss the claims provisions at the pre-construction meetings, at the pre-bid meetings.
Here's a question, and I think this is a kind of an open question, but can you impose a time limit on when a contractor must submit a claim, and is there a deadline to file a claim? So that's a good question. Ben, do you have any thoughts on that? Or
45 days is pretty much what the language says. But,
can you impose a time limit? So this is a situation of, it sounds like you're trying to determine whether or not you can say, upon notice of a claim, contractor, you have, 10 days to submit your certified or registered mail claim, which then the public agency would have 45 days to respond to. AB 626 certainly doesn't provide any guidance on that, so that would be an open question. I think that if there is a reasonable time frame that is required of a contractor to submit a claim, and then you still allow for the claims process that's set forth in 9204, I think that's certainly defensible, and that wouldn't be inconsistent with 9204, because 9204 is only saying that if there is a claim submitted, here's the process for dealing with it. But if you want to place a reasonable, limitation on when a contractor could submit a claim, I think that can be defensible. But that's an open question, and it's unclear at this point.
So we have run out of time. For those of you who do have questions that are outstanding that we did not get to, we will be downloading all these questions and we will be answering you specifically. For those of you who are clients, please make sure that you understand that we will take care of you. Before we leave, I wanted to thank you for the opportunity to present this information to you. If you have any questions that you couldn't think about during this webinar, feel free to please send Eric or I any questions via email. This slide contains our email addresses and our telephone numbers, and you can also find us on the Myers-Nave website. I also want to give a special thanks to one of our colleagues who's not on this webinar, but who is very instrumental in developing the slide packet, and that's Denise Pisano, one of the attorneys in our Myers-Nave offices. And I also wanted to thank Stephanie Hill for moderating this today. So thank you very much. Thank you for your attention, and thank you for participating in this webinar.
Great. Thank you, guys.
Thank you. Thank you all for attending. We will circulate MCLE credit certificates and the PowerPoint slides early next week, as long as a document containing all the questions from today. Thanks again.